Good afternoon, Madam Chief Justice, Associate Justices, and may it please the Court. My name is Taran Wessells, counsel for the petitioner in this case, the United States of America. I'll be addressing the Fourth Amendment issue. My co-counsel, Hannah Gourdie, will be addressing the Brady v. Maryland issue. Your Honors, this Court should reverse the 14th Circuit and hold that the with police never performed a Fourth Amendment search for two reasons. First, Respondent's driveway is an open field, not a curtilage. And second, Respondent had no reasonable expectation of privacy in that driveway, even if it were protected. Turning to my first point, Respondent's driveway is an open field, not curtilage. The leading case on whether any improvement on a property is curtilage or not is United States v. Dunn. In that case, this Court gave 4 factors to determine whether an area is curtilage. Those factors are first, proximity; second, whether the area is enclosed; third, the use that the property is put to; and fourth, whether the petitioner has put that property to any use, whether that property has been protected from public view. Turning to the first prong, the driveway is not proximate to the home in this case. In United States v. Dunn, this Court held that a barn only 60 yards away from the home was too far to be proximate.
Counsel? But it was a barn. This is a driveway where people come and go. Isn't that really distinguishable, Counsel?
No, Your Honor. I would disagree with that, because the question is proximity, not the inherent nature of improvement. Any improvement may be curtilage or it may not be. And lower courts have held that driveways are not curtilage if they're not proximate. In this case, the driveway is not proximate because it covers a 20-acre estate. That's 96,200 square yards.
So the driveway is 96,200 square yards?
No, Your Honor. However,
we don't have any information in the record, do we, about how long the driveway is, how big it is, and how many of those acres the driveway actually covers, do we?
We don't have an exact map of the property, Your Honor.
But
however,
we also don't know where the driveway was in location to the house.
No, Your Honor. As I said, there's no map of the property, but we can reasonably infer from the record that the driveway serviced the entire property, and the property is 96,000 square yards.
Wasn't there a pretty tall fence here?
There was, Your Honor, but that would go to the enclosure factor of the Dunn factors. In this case, the proximity factor weighs against Respondent because it covered such a large area, and a mere 60 yards away from the home is enough to make an area not proximate. The second factor also weighs against Respondent, and that's enclosure. In Dunn, there was a property fence like the one in this case, but it surrounded a ranch property with many outbuildings, similar to this property.
The Dunn fence was a privacy fence?
The Dunn fence was a cattle fence to keep livestock in, Your Honor. But
so that it was, I could easily see all aspects of the farm from the street, couldn't I? And Dunn?
Yes, Your Honor.
So that makes it very different than this one, doesn't it?
Not necessarily, Your Honor. In United States v. Oliver, this Court held that a field surrounded by a fence with a keep out sign that was with barbed wire was not enough to make that field a curtilage. It was still an open field, and that's the leading case on whether open fields are protected by the Fourth Amendment. For that reason, the fence is not dispositive of the enclosure issue. What would be dispositive is if the driveway were contained in a separate interior fence surrounding the home as well, like the fence in Dunn, which surrounded the home and the garden. Because there's no fence of that nature, that factor weighs against Respondent.
What kind of fence would someone need to have on big property?
Yes, Your Honor. A fence maybe lining the side of the driveway and going around the entire house would enclose the driveway and the home itself.
Doesn't this fence do that?
No, Your Honor. This fence surrounds the entire property.
So what if I want to make use of my entire property as if it was my home? What if I freely want to wash my clothes outside and hang them outside, if I eat outside, if I sit around a campfire outside with my family every night, all within my enclosed fenced property? Would that make it all part of my curtilage?
It'd be highly irregular under this Court's precedent to hold a 20-acre property entirely curtilage. Under United States v. Oliver and United States v. Hester, which is 100 years old, this Court held that large expanses of property are not inherently curtilage. They must be tied to the home, and this driveway was not sufficiently tied to the home under the Dunn factors.
Counsel, isn't it just time for us to reconsider those holdings? They're old, the technology has changed, the expectations of privacy have changed. I mean, we're arguing about curtilage, the kinds of fence. shouldn't we be focusing on what the expectation of privacy is?
Yes, Your Honor. However, under United States v. Oliver, the curtilage question is tied to the question of an expectation of privacy. Whether a property is curtilage or not depends on the expectation of privacy that someone has, whether it is the expectation someone has in a home or in their unrelated property. That's what the done fact is analyzed, whether someone has enough of an expectation of privacy in an area for it to be considered part of the home. But the done fact is way against respondent in this case.
So the police officers could have just gone onto the driveway. I mean, why use the drone? They could just walk on the driveway.
Yes, Your Honor, that would be different.
So why didn't you do that?
Well, because they used the drone instead, Your Honor.
You're saying they could have gone on the driveway?
I'm wondering how they would have had access to that.
They wouldn't have had free access to
Why
a
is
drone.
that?
Because there's a fence with a gate. However,
Okay, so there was a fence
yes, Your Honor.
that blocked the driveway, so the police officers couldn't go on the driveway. That would seem to undercut your argument.
Your Honor, under United States v. Oliver, there was a similar fence keeping the police from going without jumping over the fence. But that's what the police did. The police could have scaled the fence in this case, but they didn't. Instead, they chose to use a drone. That
But
doesn't.
would it have been okay? Would we be okay with that if the police had scaled the fence?
That's not a question that.
Well, it is a question that I'm concerned about because, right, in order for me to decide that this area was freely available to the police and therefore entitled to no Fourth Amendment protections, as you're suggesting, then I have to also find that in this circumstance that the police are free to scale the fence and wander around the property as they see fit.
Yes, Your Honor. That question is not one that this court has addressed directly, and it is an important question to answer. However, if this court held that anything surrounded by a tall fence was inherently a curtilage, it would overturn 100 years of precedent. And it's not necessary for the court to decide that in this case.
Do we have to decide that it's curtilage in order to decide that it isn't open field?
Yes, Your Honor. That's a binary question. The third factor of
There's no third choice?
No, Your Honor, there's not. The third factor of the done factors is the use, and that's the factor that weighs most heavily against respondent. The respondent here used the driveway as a commercial and an illicit factor in his use of his
So
property.
you're saying people could just come in, grocery store operators just could come in at whim and enter the property, and maybe other people too who wanted to buy food?
Yes, Your Honor. Page 2 and 3 of the record show exactly that.
There was no code, there was no special access entry for any of those people?
There was a code, Your Honor, but respondent had no supervision of their use of that code.
So everybody in the public had access to that code and could enter that property at any time, is that what you're saying?
Not precisely, Your Honor, but any member of the public theoretically could have gained access through any unsupervised access using actual codes that were given
But
out.
where would they get the code from?
The people that were given the code by respondent, Your
By
Honor.
respondent. So it's not everybody in the public who could go there, it's those individuals designated by the owner.
That's true, Your Honor, under the respondent's subjective expectation of privacy. But his objective expectation doesn't cover that because respondent abdicated any control over who entered his property by not supervising any of the visits that those grocers made.
Well, but counsel, I understand the argument about what they did once they got there, but in terms of who could enter, he didn't advocate that. And he presumably kept track of the folks to whom he gave the code, right? I mean, it wasn't everybody in the public. It wasn't published online or in a newspaper, was it?
That's true, Your Honor, but the record is silent on whether he included any caveats to that license. Respondent may have allowed anyone to enter along with the grocers, maybe
But
to help carry.
aren't we bound by the record that is before us? We can't just decide that because the record doesn't speak to an issue that it means that the owner did something other than what we know. And what we know is that the owner controlled who got these access codes. And he gave unique access codes. It's not that he just gave a single access code to a number of people. He provided each person a unique code.
That's true, Your Honor, but the corollary to your point is that we can't necessarily say that
We can't
something was-
necessarily know, right, what people would do with the codes that they received. You're right, I could probably take a code and give it to a friend of mine and have them go pick up the things and the owner wouldn't know any better. But that doesn't relinquish the fact that he subjectively, appropriately expected that this gave him a certain level of privacy. I mean, in much the same way the privacy fence, even around a very small part, if it was within 5 feet of the house all the way around and therefore totally enclosed in curtilage, does not mean that people from outside could not scale that fence and go into the property. That doesn't mean that the owner doesn't have control over access to the property, does it?
No, Your Honor, but under Minnesota v. Carver, a commercial use, and especially an illicit use of a property, gives a person a much less intense privacy interest in that property.
But Carter's a very different case, isn't it, counsel?
It is, Your Honor.
What was the issue there? Well, it certainly wasn't this issue.
No, Your Honor. The issue there was whether visitors to a home had an expectation of privacy in that home.
Whether they have standing to raise a Fourth Amendment claim, right?
Yes, Your Honor. But the underlying question was whether they had an interest in privacy, and that's the same question in this prong, which is whether there's an interest in privacy in the commercial and illicit commercial
But in
use of the
Minnesota v.
private.
Carver, though, we found that the visitors may not have had, right, that expectation, given their illicit nature and the purpose for their visiting the home. We didn't find that the homeowner didn't have an expectation of privacy, did we?
No, Your Honor. But the question of
The
whether.
homeowner clearly did.
Yes, Your Honor.
Right?
Yes, Your Honor. But
Counsel, you're spending a lot of time on the curtilage question, and just on the off chance that we will get you on that, I'd like to understand the rest of the portion of the question. So say I control a police department, and I'm the chief of police. I just think it would be really great to have drones flying all over my locality to check on things. So I send out random drones to check backyards because there might be marijuana plants, there might be other things going on. Can I do that without any violation of the Fourth Amendment?
it's unlikely, Your Honor, because dragnet searches have been held to be unconstitutional by this
Well,
court.
but counsel, I thought your argument was it's not a search.
That's true, Your Honor.
So if it's not a search, is it?
It doesn't matter if it's dragnet.
Correct? That you can do whatever they want, if the Fourth Amendment doesn't apply.
Well, that's true, Your Honor. Under Sorello v. Riley.
Really, the police chief can send out dozens of these drones?
So long as they're in public thoroughfares, yes, Your Honor. Under Sorello and Riley, this court held that so long as the police are operating in a public thoroughfare and seeing what the public could have seen, then they aren't performing a Fourth Amendment search, because there's no reasonable expectation of privacy that the public wouldn't have seen the same thing.
But counsel, those are very different cases. Once an airplane was a helicopter, considerably higher. These drones can go very close to the ground and not be disruptive, and intrude on people's privacy just instantly. Isn't that a very serious concern under the Fourth Amendment?
It is, Your Honor, but it's not one that this court has to decide today. Further, the doctrine in Florida v. Hardinus would control on that issue. If the drones fell into the close of the property, then they would be trespassing, and that would be a Fourth Amendment search. However, page 6 of the record shows
But
that
not
this.
if it's not a,
I'm sorry, the record doesn't reflect the altitude that the drone is flying at, is that correct?
That's true, Your Honor.
Okay, so what is the minimum altitude? When would it become a trespass? Below what level?
That would depend on state law, Your Honor, and the extent of the IQLM rule in that state. However, and there's no information on the IQLM law in the state of Jefferson. However, it was held by the district court that this drone was in the public thoroughfare and never trespassed on
counsel,
property.
I guess I don't understand that argument. Why is state law binding here on us? We're talking about a Fourth Amendment concern.
Yes, Your Honor, but if the question is whether it was a trespass, that would be the state property law, because property law is inherent.
Right, but the plaintiff here wouldn't be arguing it's a trespass. He would be arguing that it affected his reasonable expectation of privacy. Those are related issues, but they're different, aren't they?
No, Your Honor. The Katz analysis is separate from the Florida v. Hardinus and U.S. v. Jones analysis. In U.S. v. Jones.
Jones, the GPS case?
Yes, Your Honor.
Yeah, but that too was very different, wasn't it? That was actually planting the device on a car.
Yes, Your Honor, but the question there was a trespass. If the police trespassed on the property, then it was a search. For that reason.
I thought one of the concerns in Jones was, okay, police are welcome to tail somebody for however long, but police cannot tail somebody with a GPS can. And so the concern was, with modern technology, it may be theoretically possible for someone to do the same thing via different means that we've upheld, but not with this technology. Drone striking is very similar. A drone is much smaller than an airplane or a helicopter. It would be much harder for a chief of police to send out random airplanes and helicopters to check on people. But it wouldn't be that hard to send out random drones. And you're saying that that's not a search, and the Fourth Amendment doesn't apply.
Yes, Your Honor. Madam Chief Justice, my time ran out. May I answer Justice Grove's question and conclude? Justice Grove, the dispositive question in Jones was whether there was a trespass or not. And in this case, there was no trespass, so there was no search. For that reason, we urge the court to file a petition. Thank you.
Chief Justice, and may it please the Court. My name is Hannah Gourdie, and I represent the United States. The United States respectfully requests that this Court reverse the holding of the 14th Circuit and find that the right to exculpatory evidence does not extend to the plea bargaining phase for two reasons. First, the Brady right is a trial right alone. And second, Respondent's plea was valid in this case, regardless of whether Brady applies. His plea was knowing and voluntary, and even if Brady had applied, no Brady violation occurred in this case. Turning to my first point, under Brady v. Maryland, the right to exculpatory evidence is linked to the trial context. Indeed, in Brady v. Maryland, this Court held that the right to exculpatory evidence is important in order to ensure the fairness of a trial, and Brady's progeny have reiterated that holding.
Well, wouldn't that apply equally then to the plea bargaining process? Giving information to the lawyer on the other side helps her decide whether there is going to be a trial.
Your Honor, it would not require the right to exculpatory evidence to be extended to the plea bargaining process. And this Court has made a similar ruling in United States v. Ruiz. There, the Court held that there is no right to impeachment evidence during the plea bargaining stage.
But counsel, let's go back to Brady. With Brady, we're talking about material evidence that could seriously affect the outcome of the trial. That's considerably different from impeachment evidence, isn't it?
Your Honor, in the context of plea bargaining, the standard that the Court would need to look at is not whether, or not exactly how the evidence would affect the outcome of the trial, but how the evidence would affect the outcome of the plea bargaining process.
Well, but I assume defense counsel would want this information so that she can make a knowing decision advising her client whether to take a plea offer or not.
Your Honor, under this Court's precedents, in order for a defendant to make a knowing and voluntary plea, exculpatory evidence is not necessary because a defendant's own voluntary admissions form the basis for their conviction.
So there's a holding from this Court that says Brady does not apply to the guilty plea?
There is no explicit holding from this Court saying that Brady does not apply to a guilty plea. However, in Tillett v. Henderson, this Court held that a guilty plea is a break in the chain in the criminal process. Once a defendant pleads guilty, their admissions form the basis for their
Well, counsel,
conviction.
that brings me to this question, right? He didn't enter a straight-up guilty plea. He wasn't required to, as part of his colloquy, articulate to the court the things that he had done or that he was in fact guilty of the crime. He entered an Alford plea. And in that, it's very different, right? Isn't it up to the prosecution then to articulate to the court what evidence that they have against him, and all he has to do is admit that or concede that the prosecution's evidence is sufficient to obtain a conviction?
Your Honor, the fact that Mr. King entered an Alford plea does not make a difference in this case. Under the federal rules of criminal procedure and case law, Alford guilty pleas and guilty pleas are treated in the same way.
Well, at the back end, I agree that they're treated in the same way in terms of it being a self-supplied conviction. But in terms of what constitutes like evidence that somebody might need in order to determine what plea to enter, when you're conceding to the court that the government has sufficient evidence on which to convict you, when in fact the government does not have sufficient evidence on which to convict you.
Here, the court would need to look at, when reviewing whether a guilty plea is valid, is whether there's a factual basis for the plea.
Well, isn't that precisely the problem here? Even if Brady does not apply to guilty pleas writ large, what about the Sixth Circuit's approach that says when the exculpatory information goes to the factual innocence or guilt of the defendant, that's pretty material?
Your Honor, the Sixth Circuit, that's one approach that the Sixth Circuit has taken. However, this court recognized in United States v. Ruiz that for a defendant's plea to be knowing, the defendant needs to understand only the general consequences of waiving his trial rights. He does not need to understand the specific consequences of doing so. And as a result, the defendant needs to understand that he is waiving the right to access exculpatory evidence during the plea bargaining stage, but not the evidence that the court or that the government has against
So
him.
essentially under your theory, right, what we're saying is if I'm going to enter a guilty plea on behalf of myself, right, all I have to know is what you've charged me with and what my punishment will be if I get convicted, and what my punishment will be if I agree to enter a bargain with you, but that I don't actually have to know what evidence you have or whether that evidence would be sufficient to support my conviction?
That's correct, Your Honor. This court...
Really, even if there's absolute bombshell evidence that would be exculpatory, the defendant is not entitled to know that in order to enter a plea?
Evidence that is exculpatory, just because evidence is exculpatory does not mean that the defendant gets to have access to it, even in the trial context. Under Strickler v. Green, the court would need to consider whether there's a reasonable probability that had the defendant had access to that evidence, whether he would have pleaded guilty or gone to trial. And under Brady v. United States, this court can take into account not only the factual evidence in the case, but also different factors, such as personal factors pertaining to the defendant, perhaps like the length of the sentence he is facing. And here,
But in essence, I mean, essentially what you're saying, if we agree with you, is that all the prosecution has to do to obtain a conviction, right, and maintain its high conviction rate, right, is to overcharge every defendant, right, whether the prosecution can prove it or not, withhold the fact that they can't prove it, and then offer the defendant the opportunity either not to spend a lifetime in prison or not to receive the death penalty, or, you know, simply not to receive 5 years in prison, but to take 1 year in prison or 5 years in prison instead.
Your Honor, no. Here, under Brady v. United States, the government cannot misrepresent its case or make unfulfillable promises to...
Counsel, wasn't the government misrepresenting its case by saying we've got the goods on you?
No, Your Honor, the government was not misrepresenting its case. The government admitted the original video footage. However, the government never made the specific argument that Mr. King was the individual in the video footage.
They were charging him with the crime.
Yes, Your Honor, they were charging him with the crime. However, as page 5 of the record reflects, there was over 1,500 kilograms of marijuana found on Mr. King's property within an enclosure in a dilapidated greenhouse in the very place where someone running a drug dealing operation...
Your co-counsel is...
Didn't your co-counsel just argue that the property was open to the public, right? So, as far as issue number 1, you're asking the court to believe that anybody could access this property. So if anybody could access this property, wouldn't that suggest then that there's a possibility that the drugs found did belong to Mr. King because they weren't found on his person?
No, Your Honor. The drugs found on Mr. King's property were within a fenced-in enclosure in a greenhouse on his property. Mr. King is a farmer. He was cultivating produce on his land, and the fact that his land was only 0.03 square miles indicates that it was not that hard to keep up with.
But Counselor, if you want the court to believe on the one hand that this property was open to the public, right? That even though he used a code system that he gave to people that he wanted to enter property, the co-counsel argued that anybody could enter this property, and therefore it was not, he didn't have a reasonable expectation of privacy because anybody could enter this property. So notwithstanding the fact that the drugs were found in the greenhouse, we could still argue that anybody who entered this property could have put those drugs in that greenhouse. So if we're saying that this is a property that's accessible to the public, wouldn't the idea that if you're arguing that, then Mr. King's argument on the second issue, you have some exculpatory evidence here, right, that suggests that he did not know that those drugs were on his property. If you're maintaining that anybody could have accessed his property, so it seems to me that those two arguments can't work together.
Your Honor, my co-counsel did argue that Mr. King opened up his property to certain members of the public using a unique access code. However, under this argument, Mr. King could not have realized that the drugs were in his greenhouse because...
Well, is that really true? I mean, I thought the greenhouse was one at the far end of his property, right, as far away from his house as it could possibly get, and that as opposed to the other greenhouses that he was actively using to grow produce, this particular greenhouse was in a dilapidated condition, which demonstrates that perhaps this man who's been caretaking his property all along has not been involved in that greenhouse.
Your Honor, the fact that the greenhouse was dilapidated perhaps indicates that Mr. King was hiding the drugs in there. And moreover...
Counsel, under your argument, does it matter?
Your Honor...
Say the police actually had footage that 20 people had snuck onto the property, having gotten the codes from lots and lots of other people, and they were all hanging out with the marijuana. You had that on videotape. Did you have to disclose any of that under your argument?
Did we have to disclose any of the...
And any of the footage that you found of, 20 people, 50 people hanging out with the marijuana, Were you under any obligation at the pleading stage to disclose that?
No, Your Honor, because that video footage still would not have raised the reasonable probability.
So what if that video footage showed those 20 people going to the dilapidated greenhouse, right, and cultivating and growing the marijuana in that greenhouse? And supposing with these hours of video, right, that we have, we show the defendant never going to that corner of the property.
Your Honor, it would still, if the video was even hours long, if Mr. King did not believe that he was not one of the individuals in that video, he still could have gone to trial and contested his innocence.
But you're
there.
suggesting that he go to trial and contest his innocence when, at best, the government is telling him that they have a blurry video of someone who's engaged in this, right, activity, right, but there's no evidence, right, that supports his theory, which was that it wasn't him. And so he's going to risk 10 years to life, as opposed to taking the 5 years that you're giving him, which brings me back to my original question is the reason why 97% of all cases end in plea bargains because the prosecution is overcharging and then offering good deals to scared individuals who would rather spend 5 years in prison than risk losing their life.
And counsel, you're thinking about the answer to that. I'm curious, do you know what percentage of cases ended in plea bargains at the time that were even relevant to cite? Because I'm guessing there's a lot of people.
Your Honor, I can't speak to that point exactly. I don't have that statistical data. However, the fact that 90% of convictions in this country come from plea bargaining indicate the very mutuality of advantage that plea bargains offer to defendants and the government alike. They provide a flexible, cost-saving tool that allows defendants to bargain down sentences like Mr. King did here and saves government and defendants the cost of going to trial.
Well, I think you can make a very strong argument that it can be quite fair and quite useful for everyone, so long as the defendant has all the necessary information in front of them. Because I'm still trying to understand why the government resists providing that information.
Your Honor, because the government resists providing that information, or the government argues that this court should not extend that right because extending it would stymie the administration of justice. Yes, Your Honor. Under Agers, the prosecution has an independent and ongoing obligation to turn over material exculpatory evidence. And evidence that is material at the plea bargaining stage is that which would have changed the outcome of the plea bargaining process.
Counsel, if this defendant had been given access to the video and seen actually shows another guy, don't you think that would have changed the outcome?
It might have changed the outcome of a trial, Your Honor.
Of the plea bargain, do you think he still would have pled guilty?
Your Honor, with access to that enhanced video footage, there is not a reasonable probability that he would have pleaded guilty. Returning to the point.
So if that's really true, go ahead.
Let's suppose the record doesn't include the plea agreement in this case, right?
That's correct.
Okay. Would you be okay with a rule that said, as long as the plea agreement says you're waiving all rights you have, including the right to exculpatory evidence that the prosecution might have in its possession, as long as it sets that out, then would that be acceptable? Because I would imagine the plea agreement probably didn't say that.
If within the plea agreement there is a waiver of the right to exculpatory evidence?
Yeah.
Your Honor, under.
Didn't we know it's knowing and voluntary? Would
Yes.
that be acceptable?
Yes, Your Honor. A plea can still be knowing and voluntary even without access to exculpatory information because, as under United States versus Ruiz, for a plea to be knowing, a defendant need only know the general consequences of waiving his trial rights. For those reasons, we ask that this court reverse the 14th Circuit. Thank you.
And before we start on the next, the people watching the feed would just like the judges to speak up a little, especially the judges on the ends.
May I proceed, Your Honor? Honorable Chief Justice, Associate Justices, and may it please the Court. My name is Alexis Dalton, and I, along with my co-counsel, Mr. Alexander Steiger, represent Mr. Riley King, the respondent in this case. I will be addressing the violation of Mr. King's Fourth Amendment rights, and my co-counsel will be addressing Mr. King's due process Fifth Amendment claim. Mr. King respectfully requests that this court affirm the ruling of the 14th Circuit and hold the petitioner's actions constituted an unreasonable search for two reasons. First, Mr. King had a subjective expectation of privacy in his home and his property as required under CAP of the United States. And second, that expectation is one that both this court and society have held as being objectively reasonable.
Counsel, do you agree that if a plaintiff went over and he was seeing marijuana, that there's be a totally different case than a Fourth Amendment violation?
Yes, Your Honor, there would be no Fourth Amendment violation because that would be analogous to Serralo. However, that's not the case of Barr. In the case of Barr, we have several differences, and that goes to the second prong of the CAP test, which is an objective expectation. So, for example, in Serralo, what we have is first a naked eye observation. There was no naked eye observation because there weren't even law enforcement officers viewing directly what they were seeing on the ground. It was an
But counsel, we have another major distinction for the cases that you're citing. This guy opened up his property to dozens, maybe hundreds of other people who could have passed on the code to enter. Is subjective expectation of privacy if dozens or hundreds of other people can come onto your property, let alone an objective standard?
Yes, Your Honor. So it's true in this case that Mr. King specifically opened up his property to third parties. And so if this was a third party doctrine question, such as that established in Smith v. Maryland or United States v. Miller, then yes, if those third parties, for example, were to go to law enforcement and say, this is what we found on the property that he invited us onto, we would not have a Fourth Amendment violation. However, and I believe that it was your Justice and Your Honor that pointed out that this was not a property that was open to the public. It wasn't knowingly exposed to the public because a unique key access was given to each individual. Mr. King had to give that access to each individual.
To presumably a lot of individuals.
That's true, Your Honor. However, he still maintained that protection. He was still in control of who accessed the property. And that's true once he had given it out, they were free to come and go. But he
didn't supervise them once they came up.
That's correct, Your Honor. However, it's still distinguishable from a third-party doctrine case because from a knowingly exposed to the public case, because in that case, an individual has no control procedure. For example, this court held in the United States v. Knox that when an individual drives on a public thoroughfare, that he has no objective expectation of privacy, specifically because he cannot control who's going to look in his vehicle. It is notable, Your Honor, and this answers the first part of your question, that in Knox, this court stated that there is still a subjective expectation of privacy, it's just not reasonable. And here we have both a subjective expectation of privacy, one that is reasonable. And that leads to Petitioner's main point, which seems to be that this is not protected curtilage. However, Petitioner is substantially misstating the law under the Dunn factors for two specific reasons. First, as to the second of the Dunn factors, which is an enclosure, there's no requirement that there be a separate enclosure for the driveway, which seems to be what Petitioner is arguing here. In Dunn, we have several fences. We have one privacy fence that surrounds the home. We have a cattle fence that surrounds the barn. Police are able to look through the cattle fence and see the barn, and the privacy fence attached to the home is in no way attached to the barn. Here, Mr. King, the record of page 2 specifically states that he took the pains and the efforts to construct a privacy fence not just around his home, but around his home, his driveway, his curtilage.
Counsel, say we agree with you on that point. I'm still trying to figure out how is a drone different from other objects that might be flying. Other people can fly over and see stuff. How is a drone different?
You're in two ways specifically. So this case is not analogous to Searle v. Riley, specifically because there's no naked eye observation. The second is because the technology used here is not the type that is in general public use.
So do you think our decision would have been different in Searle or Riley if what had been used was a camera with 180 times zoom?
Yes, Your Honor, specifically because then we have
So if I was riding in an airplane and like to take pictures of the ground with my 180 times zoom camera, that would be unreasonable?
Only if you're not able to see the same thing with a naked eye observation, and that is what Cairo v. United States is essentially.
Counsel, are you suggesting that drones are not in common use by the public? Was that your point?
Your Honor, and this is where Respondent would specifically disagree with the holding in the district court that's in the record. The record at page 6 makes a big deal of drone technology being generally available to the public. but this court in Kylo did not use that terminology. There is no terminology of generally available. The court specifically said in general public use.
Well,
And then-
it is in general public use, isn't it?
Well,
I mean, I
yeah.
was in Costco recently, and there was a whole section of drones under a couple $100.
My son asked for a drone for Christmas. He
Are
said
you
it-
going to get them?
No.
Your Honors, and to both your point, that would go to it being generally available to the public, which could be a factor in determining general public use. But the court in Kylo, specifically in footnote number 6, stated that by general public use, what they're stating is that it is routinely used. And here, it's important to note that not only do we have drone technology, we have sophisticated drone technology. These officers, the record states, had to go to a hill that was several miles away from Mr. King's property. That's where they launched the drone. The drone was then able to reach Mr. King's property and hover there for several hours. So we have a sophisticated technology, and it's not just that technology either, Your Honors. It's also the 180 times magnification that you were referencing earlier with regards to Sorella.
Does it matter whether this would be a trespass if a private individual had done this, or is that totally irrelevant to the Fourth Amendment analysis?
Your Honor, it does matter, although the record is silent on specifically whether or not this was a trespass. Because this is curtilage, the Fourth Amendment protects both against a physical trespass, but Katz also states that it is not necessary that there be a physical trespass. So if a private individual had trespassed, it would just be a different analysis that we would have before us. And because the record is silent, here it doesn't necessarily matter if the drone was in an area that we can consider trespass or not, because either way it does constitute a search under Kylo.
So how many people had thermal imaging equipment at the time that Kylo came down?
Your Honor, the record is silent on that point, and so we do not know as far as it being generally available. We do know that the court just stated that it was not in general public use.
But counsel, I mean, wasn't much of the argument in Kylo that it allowed the government to look inside the house, and that really does intrude the privacy of what's going on. That's why people go inside their house. This is a very different case.
Your Honor, it's true that the court did stress that the specific thermal imaging technology could see within the interior of the home, but when articulating the rule, it establishes that sense-enhancing technology creates a different position. Their only rule that they stated was that sense-enhancing technology, not in general public use, creates significant Fourth Amendment.
So does that mean that the calculus is going to change when this infrared technology becomes in the general public use, which it will likely within a few years?
Your Honor, it would depend on many factors. However, respondent would suggest that if this technology were to become in general public use, which we contend right now it is not, if it were to become in general public use, because of the level of invasiveness that this drone technology poses, not just because of the sophistication of the equipment, but the possibility that it has to survey property for extended periods of time, we would be looking at something aside, what this court has considered a
If I was in a
silent.
helicopter, I could fly for hours over a particular property, couldn't I? If I could see through the dense foliage, I could fly over it for hours and be able to observe whatever I wanted to, right?
Hypothetically, you could, Your Honor. However, it's a question of both manpower and resources. And here, if you have an
But
unmanned.
Riley said you could.
But-
As a matter of law, correct?
That's correct, Your Honor. Yes, and we're not contending that a helicopter flying over respondent's property would not be able to do the same things. However, because a helicopter would not be able to go over respondent's property, and because there would not be able to be naked eye observation, it does distinguish. And turning back to Your Honor's previous question, if this were to be in general public use, you would have a carpenter situation where a seismic shift in technology, this court should consider extending special Fourth Amendment protections to situations such as the one that we have at bar. And Your Honors, I'd like to return to my second point under the objective prong of the Katz test, which is that this is constitutionally protected privilege under all of the Dunn factors. The petitioner specifically stated that point 3 of the Dunn factors cuts heavily for the petitioner. However, petitioner overlooked that the officers in Dunn, when approaching the barn, they already had objective data that
What is
was
point 3 again?
Point 3 was the uses to which the area in question is put. So here the area in question is the driveway. And in Dunn, the officers had objective data before entering the property that the barn was not being put to uses that were consistent with the intricacies of the home. However, the officers here had no such data. The only thing that they had were anonymous tips that could apply to the property writ large. There was
But we
no,
do know, right, that he had this business, right? So at best, right, and assuming, right, because he was selling his produce to local restaurants as well as to individuals, then you could assume that the police officers knew that as well. So at best, this driveway served both as access to the home and access to the staging area.
it's true that the record states that there were people going in and out. However, the only thing that the record states is that there was a staging area next to the greenhouses in which customers would pick up their produce. And because we are narrowly talking about the driveway, that does not.
But what does that mean by driveway? There's no definition in the record for driveway, and assuming that there was only one gate that went in and out of the house, because there's no evidence that there was a second gate, right, specifically for the business, we're still stuck with the driveway at best being utilized for both purposes.
If I could answer your question in two parts, Your Honor. As to the first part, it's true. The record is silent as to the specific area of the driveway. But under Collins v. Virginia, this court has held that driveways in general are
Well, the
traditional
Collins
areas.
didn't create a blanket rule for driveways, right? In Collins, it was very specific. The court spent a good deal of time talking about the specific access, like part of the driveway where the police had broached, like specifically into the curtilage of the home. It wasn't just because they were on the driveway.
And counsel, I'm still puzzling over your distinction in our earlier barn case, you might call it. You said the police officers had more knowledge. Why does that matter to whether this is curtilage? I don't get why the knowledge matters. Okay, here you got a couple of anonymous tips, but we're trying to figure out, was there a reasonable expectation of privacy in the place?
Yes, Your Honor. If I could answer Justice Franklin's question, then I'll respond to your question as well. Your Honor, specifically here, it's true we have a driveway, and it's true that Collins v. Virginia specifically articulated reasons why that driveway was protected. However, curtilage is traditionally applied to porches and areas immediately adjacent to the home. And I believe it was both of Your Honors that pointed out when the petitioner was speaking that if we define this as an open field rather than curtilage, the police officers are not, law enforcement, they're not going to know which areas of the driveway are protected. So what we're saying by holding that this is an open field is the officers can scale the wall, survey the area, park on the driveway, as long as they don't get too close to the house. The respondent is not confident that that's a line that law enforcement should or would be able to make. And to respond to your question, Your Honor, the Dunn test, specifically the third prong, it matters because the officers have, in order to prove that there was a commercial use that wasn't linked with the intimacies of the home, officers had to first search Mr. King's area to determine that there were commercial activities going on. That's not something that they could have known before searching the area. So in fact, the law enforcement, by conducting this search, they were presupposing that the Dunn factors applied and that it was an open field. Now, for example, in Dunn, the officers, they already had photographs that showed that the barn was being put to use specifically for illicit activities. However, the law enforcement here, they had no information specifically regarding the driveway until after the search was conducted. So it was necessary for them to assume that it was an open field, go in, get the information, and then they tried to justify it later that what they did was consistent with the Dunn factors. Your Honors, Mr. King had a subjective expectation of privacy. That subjective expectation is one that this court has consistently held as objectively reasonable, and for these reasons, the respondent respectfully requests that this court affirm the ruling of the 14th Circuit. Thank you.
Thank you, counsel.
May I proceed, Your Honor? Honorable Chief Justice, Associate Justices, may it please the Court. My name is Alex Steiger, and I represent the respondent, Mr. Riley King, and this afternoon I will be discussing the Brady due process issue. Mr. King respectfully requests that this Court affirm the United States Court of Appeals for the 14th Circuit and vacate his guilty plea for the following two reasons. First, the Brady right to exculpatory evidence is a due process right and extends to the plea bargaining stage. And second, the government violated Brady by withholding exculpatory evidence. Turning to my first...
Just very briefly, before you get to the argument about that, do we have to address both issues in this case for you to win?
Yes, Your Honor. This court specifically held in Tollett that
I mean, both your co-counsel's issue, the search issue, and the Brady issue.
No, Your Honor. If the search was invalid, then the conviction would be impermissibly based on an illegal search and would be unconstitutional.
So the evidence would be suppressed.
That's correct, Your Honor. Turning to my first point, the Brady right to exculpatory evidence is a due process right and extends to the plea proceeding because it is a due process right and because this court's reasoning in United States versus Ruiz does not specifically preclude extension of the right to plea proceedings.
So, counsel, if we rule in favor, in your favor on the Fourth Amendment issue, we don't have to, it would be improper for us to address the Brady issue?
Correct, Your Honor, but assuming that this court were to find in favor of the government on the Fourth Amendment issue, then the Brady issue would still invalidate this guilty plea.
And if we wanted to reach the Brady issue, but we don't actually believe that this particular the evidence at issue in this case would be fall within the gamut because we don't think that it's material to either his decision to plead guilty or not, or material as to whether a jury would find him not guilty, right? Then could we just rule on the actual constitutional issue, but then nonetheless find that as applied to your client that it is not applicable?
Your Honor, if this court were to find that the Brady right extends to the plea proceeding, then this court will find that the government committed a Brady violation by withholding the drone footage from Mr. King at the plea proceeding.
But do we have to?
Yes, Your Honor, in order to invalidate the guilty plea. The Brady right is a due process right at its core, and that means that it extends in any proceeding where a defendant's liberty interest is at stake. That would include a plea proceeding. In Matthews versus Eldridge in 1976, this court established 3 factors to look for to determine the vigor with which a due process right must extend in any given proceeding. And those factors are the private interest at stake, the value of the additional safeguard, and the burden on the government's interests.
Do we need Matthews v. Eldridge to decide that Brady applies to the pleading stage?
Your Honor, those factors are the factors that this court looks to determine the vigor with which a due process right extends, and because Brady is a due process right, this court must rely on those factors based on that.
But given that we've never actually, did we actually hold that Brady only applied as a trial right?
No, Your Honor, this court has never held that.
So it's just what everybody has assumed?
Some circuits have assumed that, Your Honor, and those circuits would be relying on United States versus Ruiz and a misinterpretation of that case.
But Brady itself talks about the significance of the trial, doesn't it, counsel? And that's why the material evidence has to come out.
Yes, Your Honor, but the specific holding of Brady versus Maryland was that it is a due process violation for the government to withhold exculpatory evidence. And this court said that that was important in relation to the fairness of the trial, but it did not say that was the reason why it was impermissible for the court to do that. The 3 factors to determine whether the Brady right should extend all weigh strongly in favor of extending the due process right to the plea proceedings. First, the private interests at stake in this case are immense. As the record reflects on page 8, Mr. King's plea agreement that he arranged with the government not only was going to impose a 5-year prison sentence on Mr. King, but was going to require him to forego all of his constitutional rights associated with a trial. Second,
So he was represented by a lawyer, yes?
That's correct.
And he knew what he was doing. It actually looks like a pretty good deal with that, doesn't it?
Your Honor, no. By withholding the enhanced drone footage, the government compromised Mr. King's ability to make a knowing and voluntary guilty plea.
But what difference does it make if the guilty plea is, if he had all of the information, if the reality is that had this gone to trial, even if he fully knew that that drone footage clearly showed his tenant engaged in that one transaction, the jury would still be weighing close to 30,000 pounds of marijuana that were found on his property in both plant form and powder or leaf form.
Your Honor, that is Mr. King's right to decide whether or not to enter a guilty plea and to go to trial, or a not guilty plea and go to trial. At a minimum, Mr. King is entitled to his due process rights to make a knowing and voluntary decision with respect to that, to the decision to go to trial.
Well, he had those rights satisfied. He was represented by counsel. He understood the charges. He understood the potential sentence. And the judge ultimately had to pass on this to make sure it was a valid guilty plea. That's due process, isn't it, counsel?
Perhaps, Your Honor, but this goes to the question that you asked Petitioner earlier, and this goes to the second due process consideration. In other words, the additional value of ensuring the procedural safeguard during plea proceedings, and that is that it enhances the right to counsel, which this court...
Well, but counsel, if you take that position, then don't we want to extend Brady all the way? Let's be real about it. That as soon as counsel appears on the horizon for the defendant, government's got to turn over everything that might be material. And that way they can understand how to go forward, maybe with a preliminary hearing, or in discussing it with witnesses, and whether or not the family wants to put up the money to support counsel. I mean, it goes all the way, doesn't it? And Brady certainly doesn't speak in those terms.
Your Honor, the question before the court today is whether the right extends to the plea proceeding, and that is the extent to which the court should consider how far Brady extends today.
On the flip side, is Brady not applying when a petitioner, when a criminal defendant does not have counsel, say, on direct appeal, they can't get counsel's pleasure?
No, Your Honor. No, Your Honor. The Brady right does not apply simply because the defendant does not have counsel.
So it could go back further.
Perhaps, Your Honor, but the question in this case is whether the Brady right extended during the plea proceeding, irrespective of whether the defendant had counsel.
So counsel, I want to get to the other Matthews v. Eldridge factor, and that's, if you're going to use that test, and that's the government's interest. I'm trying to envision a world of plea bargaining where the government has to turn over, at whatever stage, any information it has that could be material to the defendant. Wouldn't this completely hamper the plea bargaining process?
No, Your Honor, it would not. And this government in the United States versus Ruiz specifically said that the government has an interest in obtaining guilty pleas. However, there's no indication that that right is being burdened already. And if the token gesture of disclosing exculpatory evidence were to overwhelm the judicial system, especially given that 97% of all criminal proceedings end in guilty pleas, if that were to overwhelm the judicial system so much, then perhaps that's a reflection that the judicial system is failing.
Well, counsel, that brings me to a question, right? If the government has the capability to enhance video so that they could see things that they couldn't see in the first pass, would Brady require that the prosecution use that technology to enhance video to ensure that it doesn't contain exculpatory evidence?
Your Honor, that question is beyond the scope.
Well, it isn't really, right? Because that's part of what happened here. And we were talking about the burden on the government. I mean, I'm already thinking about the hundreds of thousands of hours of video that prosecutors are now having to review from police body cams. And I mean, right, if they have a duty to look for the exculpatory evidence so that they can turn it over, because if it's in their possession, right, if it's in the police possession, it's in the prosecution's possession, they're required, at least at the trial level, to turn it over. And if we require that at the plea bargaining stage as well, I can only imagine that justice will come to a screeching halt.
No, Your Honor, that's not quite right. The government, whether the government has a burden or a duty to enhance all evidence that it gets is not the question before the court today. And the fact remains in this case that the government did choose to enhance the drone footage, and as such, they had an affirmative duty to disclose that evidence with Mr. King.
I would get back to a question that Justice Brule asked your opposing counsel. That's about waiver. If Brady does in fact apply to the plea bargaining stage, can it be waived? And if so, didn't your client waive it?
Your Honor, Mr. King entered into the guilty plea. However, by withholding the evidence, the government prejudiced Mr. King's ability to make a knowing and voluntary plea. In United States versus Ruiz, this court specifically said that knowing is being able to understand your rights and the way they apply in a given situation without access to the full scope of the government's evidence in front of that the government was going to use against Mr. King, specifically because the government impermissibly withheld portions of that evidence from Mr. King. Mr. King's ability to fully appreciate his right to trial, all of the rights that are accompanied with that right.
Counsel, let's flip it on the other side. What if, in addition to the evidence that we know that the government had, the video and the marijuana at play, what if the government also had 5 or 6 of Mr. King's customers who were all willing to testify that in addition to picking up broccoli, they routinely picked up bags of marijuana from Mr. King, not from the tenant. Is the prosecution required to give that information to the defendant before the defendant chooses whether to risk it for the possibility of being sentenced to 10 years to life instead of taking a 5-year plea?
If the evidence is exculpatory, Your Honor, then the prosecution has a duty to disclose that evidence to Mr. King.
But counsel, your argument is that he has to make a knowing and voluntary plea. Is that correct?
That's correct, Your Honor.
So following up on Justice Wagner's question, if that information was available, notwithstanding the fact that it wouldn't be exculpatory, your argument suggests that the prosecution would have to turn that over for him to make a knowing plea. Is that correct?
That's correct, Your Honor, and that brings me to my second point, which is...
But I don't think you answered the question. So would the prosecution have to turn over that information? It's not exculpatory. In fact, it actually lends more credibility to the prosecution's case. So if, in fact, the prosecution knew that patrons or his customers they had videos that showed that they were on the property buying broccoli and marijuana directly from Mr. King, under your argument, then if he was to make a knowing and voluntary plea, he would need to know that, correct?
That is correct, Your Honor, and this court defined exculpatory evidence in United States v. Bagley as evidence that is favorable, so that if disclosed, it would be the distinction between conviction and acquittal.
Right, but
Counsel, it sounds like your answer to Justice Franklin and Chief Justice Shepard's questions is no, they don't have, the prosecution does not have to turn over evidence if it's not exculpatory.
Your Honor, the government does have a duty, an affirmative duty, that this court established in Kiles v. Whitley in 1995, and that is to disclose exculpatory evidence.
Okay, counsel, you never did answer my question about waiver. If Brady applies at the plea bargain stage, can it be waived, and how? And this goes back to Justice Brewell's question earlier. Can this be waived?
Your Honor, that question would require a deeper search into the waivability of certain rights at various stages of the criminal proceeding, and Mr. King would be happy to supply supplemental briefing to answer that question in further detail. And turning to the second issue of whether the government actually committed a Brady violation, this court established a 3-factor framework in Strickler v. Green, that being that the government has an affirmative duty to disclose exculpatory evidence, and by withholding that evidence, the government causes prejudice. Those are the 3 factors. In this case, the government prejudiced Mr. King's ability to make a knowing and voluntary plea.
So we only look as far as the plea. Is that what your suggestion is? If we were to extend Brady rights to the pre-plea stage, then do we look at materiality only to the extent that would have informed his choice? Or do we look beyond that as we would if it was a trial, in trial context, to whether it would impact the actual decision?
Your Honor, in United States v. Bagley, this court specifically said that the evidence that is withheld prejudices the defendant's ability to do anything in a proceeding if there is a reasonable probability that the proceeding would have resulted differently if the government disclosed that evidence. In the context of a plea proceeding, that would require the evidence that the defendant would have pled not guilty, and there's reasonable probability that Mr. King...
Well, then, counsel, that brings me back to that original question that I've been asking you about. What if it was additional inculpatory evidence against him? If we hold that Brady essentially applies to the plea proceeding to the extent that it would inform the defendant's choice to take the plea or to not take the plea, then wouldn't it be incumbent upon the government to tell the defendant everything that they had against the defendant so the defendant could more accurately weigh the likelihood that the government would obtain a conviction that caused him to potentially face a lifetime in prison, as opposed to taking the bargain which would limit that risk to 5 years?
Your Honor, I see that my time has concluded. May I briefly respond and conclude? Your Honor, at a minimum, Mr. King is entitled to the choice to make that decision as to whether to go to trial or accept a guilty plea. Evidence that is exculpatory would weigh strongly in favor of, especially in this case, of pleading not guilty and proceeding to trial. And for those reasons, this court should affirm the United States Court of Appeals. Thank you.
Thank you, counsel.
Taran Wessells for petitioner, and may it please the court. Drone technology is within general public use. The respondent failed to acknowledge that the FAA has registered over 5 times more drones than they have planes and helicopters combined, which the Kylo court held were examples of acceptable technology. Second, Ruiz did not open the door to accepting plea bargaining, to accepting the Brady right in plea bargaining as respondent suggested. Ruiz barred impeachment evidence and never distinguished between impeachment evidence and the Brady right. For that reason, we urge the court
Counsel?
to find.
Is the information about the FAA and the number of drones in use in the record?
No, Your Honor. It was in the brief that we supplied to this court, and we can supply it again in supplemental briefing if you'd like. For that reason, we urge the court to find for petitioner. Thank you.